Episode 6. The Verdict and Aftermath. Chapter 1. The Verdict. After two sprawling jury trials stretching months, the final panel filed into Norfolk Superior Court on June 18, 2025. The clerk read the verdicts: not guilty of second-degree murder, not guilty of manslaughter while operating under the influence, not guilty of leaving the scene, guilty only of operating under the influence. Karen Reed wept and hugged her team. The judge later imposed the standard first offense OUI sentence: 1 year of probation and completion of the Massachusetts 24D alcohol education program, which typically carries a 45 to 90-day license suspension while enrolled. Norfolk DA Michael Morrissey offered 4 words that afternoon when pressed for comment: "The jury has spoken." Chapter 2. Why the jury said no collision. When jurors spoke out, their reasoning was strikingly consistent. One juror told ABC News, "I think, with the evidence presented, a collision did not occur." Another juror told local media the panel couldn't prove there was a collision. The foreman said on NBC's Today, "Karen Reed is innocent. No one could prove that she did this crime." The thrust wasn't a mystery theory, it was a rejection of the crash premise. What fed that conclusion? First, the taillight. Dighton Police Sergeant Nicholas Barros testified that when he saw Reed's Lexus at the tow, the right taillight was not completely damaged. A piece was missing, but it wasn't smashed out as later photos appeared. Jurors also heard from ARCCA crash engineers, who actually tested exemplar Lexus taillights and dummy arms at the prosecution speeds. Their conclusion: the damage pattern on Reed's SUV was inconsistent with striking a human arm in a high-speed reverse. That technical work, the kind that replaces speculation with physics, mattered. Second, scene visibility. Canton snowplow driver Brian "Lucky" Lucran testified he made multiple passes by 34 Fairview Road in the relevant window and saw nothing on the lawn where the Commonwealth said O'Keefe lay for hours. Jurors referenced this when describing why the collision theory never solidified. Third, the medical and forensic picture. Jurors highlighted expert testimony that injuries to O'Keefe's arm and clothing didn't match the Lexus taillight mechanism, and several pointed to the defense medical experts, whose opinions undercut a car strike scenario. Chapter 3. The investigation on trial. The case within the case was investigative credibility. The lead investigator, Trooper Michael Proctor, sent crude, biased texts about Reed. He was later terminated from the Massachusetts State Police, and is now appealing that firing. Jurors said those messages undercut trust in the process. Beyond Proctor, the Canton Police Audit, a 200-plus page town-commissioned review released just as the retrial began, catalogued procedural lapses from the earliest hours: the failure to photograph O'Keefe in situ before moving him, unrecorded interviews with key witnesses, and no continuous police presence at 34 Fairview pending a secondary search. The report also described evidence handling gaps that mirrored what the jury heard in court, like bloody snow collected in red Solo cups and transported in grocery bags. The audit did not find proof of a conspiracy, but it squarely identified avoidable mistakes that erode confidence. Chapter 4. Evidence that backfired. The Commonwealth put weight on 2 pillars: taillight fragments and digital breadcrumbs. On taillight, ARCCA's testing, first commissioned by federal authorities and later supported by the defense, showed why those shards didn't prove a human impact. On digital evidence, the jury learned about phone search controversies and timeline gaps that didn't cohere into a reliable crash narrative. In the end, the parts never made a machine. Chapter 5. The price tag and the politics. The retrial became eye-wateringly expensive. Morrissey brought in Special Prosecutor Hank Brennan. Records show $566,000 in compensation tied to the second prosecution alone. Brennan's post-verdict statement defended the decision to retry, and said the evidence pointed to, quote, "one person, and only one person," a message that landed coolly with an audience already persuaded the state hadn't proved a collision at all. As for Reed's side, reputable outlets have reported millions in defense costs over 2 trials. Supporters organized crowdfunding and merchandise campaigns, but comprehensive, audited totals aren't public. The safe takeaway is that this was a multi-million-dollar defense and an extraordinary public sector spend, all to end with a single OUI conviction and a year of probation. Chapter 6. Pop culture and public pressure. Before jury selection in the retrial, investigation discovery aired A Body in the Snow, The Trial of Karen Reed, later streaming on Max. The public therefore came in primed, and the courthouse crowds were loud. Jurors insist their decision turned on evidence, not noise. But the media glare heightened scrutiny on every misstep. Chapter 7. The Civil Fight Ahead. The O'Keefe family's wrongful death lawsuit, filed in Plymouth Superior Court after the first mistrial, remains active. Post-acquittal, Reed's team has moved to dismiss several counts, and Alan Jackson has joined the civil defense roster. The criminal jury's no-collision conclusion will hover over the civil case, but the burden there is lower. Expect a long, document-heavy fight. Chapter 8. Where this leaves the story. 2 trials didn't tell the jury how John O'Keefe died, but they convinced multiple jurors that the state did not prove a collision. That matters. It's why they used the word innocent, why they said no one could prove she did this crime, and why they cited scientific testing over supposition. The broader lesson is simple and old-fashioned. Tell the truth, preserve the scene, and let the science lead. When investigators shortcut those steps, juries notice, and they hold the line. For Karen Reed, the criminal chapter closes with probation, classes, and a suspended license period. For John O'Keefe's family, the civil courts might still surface answers. For Massachusetts law enforcement, the audit's recommendations offer a map back to best practices. And for everyone who watched, the case shows how reasonable doubt isn't a loophole. It's the system insisting on proof. If you stayed with us through this series, you know why the final word belongs to the jurors. No collision, not proven, and therefore, not guilty.